welcome to Legally Speaking with me, Tarun Nangia. You know, we are doing a 5-part series on the Chief Justice of India, Justice Sanjeev Khanna. And as I would normally say, being Justice Sanjeev Khanna is not easy. It's like that you're the nephew of Amitabh Bachchan, who's a very well-known film star. Whatever you do, you'll be compared to Amitabh Bachchan if you are his nephew and come into acting. And of course, Justice Khanna has that illustrious legacy in the legal system and has to live up to it. And of course, it's not easy because in a sense, memories are long in the judicial space. And obviously, that's why he has a strong legacy to keep up to. And of course, on this show, we will discuss. We have titled it Justice Sanjeev Khanna as CJI Observations and Suggestions. I have two people who are very active in the Supreme Court of India. Advocate Mahesh Agarwal joins us. He's managing partner of ALA, which is Agarwal Law Associates, one of the leading firms at the Supreme Court of India. We are also joined by Advocate Ruby Ahuja, who's a senior partner at Karanjawala and Company, one of India's leading law firms at the Supreme Court of India. So two top law firms at the Supreme Court, both represented today on the show. Good to see both of you.
Hello.
Hello. Let me request at the outset, Advocate Mahesh Agarwal, if you could give an opening comment on how do you see Justice Sanjeev Khanna as CJI. He's not a short tenure, 6.5 months is a fairly long time. What do you think can be done in this? And any suggestions, of course.
See, Justice Khanna had a stellar career so far. He's a completely no-nonsense judge. He's patient. He hears people. You come out of the court with a full satisfaction that whatever you had to argue, you've been heard. And very, very disciplined. On the first day when he became CJI, he said mentionings are stopped now. But in a different way, in a more disciplined way, mentionings go on. We have to file letters in the morning and they're considered and then matters are listed. So every day at 10:30, there used to be a kiosk in the court. That kiosk is eliminated. Straight away you start with item 1. But I still feel that there are sometimes some cases where you cannot really express the urgency in just a letter. And a letter the urgency may be overlooked by a judge and the justice is compromised. So I think in the next few days, I think there may be some modification that something which is super urgent or the registrar clears the matter for mentioning, those matters are mentioned. But other than that, I think it's a very welcome step that mentionings are being done by letters. You write down your urgency, you write down when the judgment was delivered by the High Court, why you cannot wait, and orders are passed. So seeing Justice Khanna from the High Court, I have appeared before him for many, many years in the High Court and now obviously in the Supreme Court. He's very focused, completely legal oriented, hardly any prejudices. So I think we are going to have a great innings with him.
Okay, thank you for your opening comment. We'll go to Advocate Ruby Singh Ahuja, senior partner with Karanjawala and Company, for her opening comment.
So, Tarun, as you rightly said, that Justice Khanna has 6 months tenure, but though it is long or short, but he is not a judge in hurry. That's what I think is the biggest USP is. Mahesh says he's very patient. I absolutely agree with him. He's very, very patient, very smiling, and he gives you your time in the court. I think for every lawyer, for every client, especially, and then for the lawyer who practice in Supreme Court, since it's the last court, it is very important that the client gets his time in the court, and which he gives. He hears, he's very patient, and then he decides according to the law. I don't think so prejudice or, sometimes this thing between equity and law, I have seen him tilting towards law more. So he's a very law-based judge. I'm very, very hopeful he will have a very good tenure as a CJI in the court. Yes, he does have certain tasks at hand. First is the mentioning. He needs to streamline because just to add to what Mahesh says, I don't see Supreme Court is the only court where it is almost impossible to get a matter listed on the same day unless, it is highly, very, very important. But this is not correct according to me, because all over India in the high courts, you can get matter listed on the same day. And why should you not if it is urgent? Sometimes if you don't get a hearing in a day or two, the petitions become infructuous. So I'm very, very hopeful that Justice Khanna will come up with some plan to solve these issues. Rest, I think he will also have to. I also feel that every CJI should not only act as a Chief Justice of Supreme Court, he's the Chief Justice for other courts also. He must see what is happening in other parts of the world, other parts of India, especially the lower courts in far-flung areas which do need our attention. We have been reading in papers, security has become an issue for lawyers, infrastructure is an issue. I personally feel that whoever is coming now, whoever has the power, the authority, the office, they should focus on this also. Supreme Court will work. Supreme Court is working and it will work itself. It is one of the highest court. It gets a lot of public attention, media attention. So I think their things will get streamlined. Some days are good, some days are not so good. Sometimes some facilities are okay, some are not okay. But we have very strong bodies like SCORA, SCBA, who keep, who go ahead and give lawyers concerns, which I don't think so. The lawyers who practice in far-flung areas have a voice. And this will be my request to the Chief Justice and to the other judges who will ever come to this, that they should start looking at that as well.
Point very well taken. But you mentioned the word infrastructure, which now I'll take in a very different sense. This government is investing 13 lakh crores as announced by themselves in infrastructure. It's generating a lot of litigation. Most of it is landing up in the Supreme Court because parties have money to pay and they fight all the way up to Supreme Court. Mr. Agarwal, do you feel that for the infrastructure sector, we need some special attention because thousands and lakhs of crores is now stuck in litigation? And if courts don't give quicker resolution, then what will happen is that these companies may shy away from investing. I'm also asking you this because these companies, infra companies, are job heavy. They generate a lot of jobs for common people, which is the government of India's agenda to generate jobs. What can he do in infrastructure in your submission?
So I think what you're talking about is priorities and what matters should be given preference, what matters should be heard at the earliest, and what can wait. So I think in terms of priority, first and foremost is personal liberty. So matters where people have been in jail and maybe they have been convicted and appeals are pending, the whole appeal will become infructuous if they serve the sentence while they're inside. So matters where people are, the personal liberty has been taken away, I think deserve the maximum priority. After that, I totally agree with you that India is growing at such fast pace that we cannot afford the infrastructure industry to suffer at all. So
Yes.
in infrastructure, there are several kinds of matters. First and foremost is taxation issues. So what is happening is that they use, like I'll give you a Vodafone example, that there's a tax demand or a government demand and the matters take 10 years to be decided. The interest and penalty mount up so much that the survival of the company becomes a question mark. So matters where there are demands, they must be heard immediately so that if the government has to get its due, they get it immediately. And if the company has to save money on litigation, they can also do it. So basically, you should know the result of the litigation at the earliest. Insofar as pure infrastructure is concerned, there are several projects which are stuck up. It could be because of some environment challenge, some issues with regard to some pollution, some PIL, which hold up the projects. The infrastructure cost keeps going up. Ultimately, the infrastructure project has to come up and some safeguards have to be brought in, but they are unduly delayed. For example, the Goa airport, there was an injunction initially by the Supreme Court. It took 1 year to vacate. That 1 year added to the cost of the project. Correct? So therefore, infrastructure projects must get a priority. In fact, if possible, there should be a separate bench to ensure that all projects of importance are taken up and decided.
Okay, that's a very important suggestion that for mega projects, maybe a separate bench which can look at them closely and give quicker decisions. It could be either way, but a decision is needed.
I'll give you another example where infrastructure project, which was stopped by the Bombay High Court, Supreme Court acted with alacrity and immediately orders were passed, is the Mumbai Coastal Highway. The Bombay High Court had said because of environment objections, the construction cannot happen. The Supreme Court passed an interim order permitting the construction, and now whole city of Bombay is thankful to the Supreme Court because the project would come up.
That's a very important point. In fact, I remember both these projects I have discussed with politicians on the show, the mining minister and the Goa chief minister in one show, and with somebody in Maharashtra with the other. So indeed, politicians do welcome these kind of judgment by the Supreme Court, which are pro-development. I'll go to Ruby Singh Ahuja on this one. A lot of curatives are there in Supreme Court with regards to important infrastructure projects. But the hearing takes time, it takes delay. Do you think there should be some way to speed this up? If there is a curative, settle it quickly. It could be either way, but do it quickly. Do you think that that should also be priority? Hear the curatives quickly.
You know, Tarun, I come from a school of thought. I'm not in favor of curatives, since what I've been seeing in last 1 or 2 years, without naming the matters, the close judgments of judges who have passed judgment, and after that, I've seen when they retire, curatives are filed, and sometimes they are opened. I see it is all very well to say that there should not be any illegality and Supreme Court is the custodian. I totally bow down to that. I practice there and I know that. But where do you end? Where do you end? Any judge of the Supreme Court who has passed any judgment may have a viewpoint. Now, if that view and the other judge may have another viewpoint, unless and until you show a drastic, glaring error on the facts, I don't think so. There can be any other reason that curative. You please remember, initially there was no curative petition. Supreme Court judgments used to end by disposal of the civil appeal, maximum a review, which was heard in chambers and matters ended. Then came Ashok Hurra, Rupa Hurra, and the curative started. Now, unless maybe we can carve out that if curative leads, if it is a personal liberty issue, you can have a curative. But to have curative petitions in a commercial matter, how will anybody do business? How will an investor invest? Because, right, you get a judgment, you say, okay, thank you, it is closed. Now, after 1 year, everything is open. So, yes, if we really want to do curative, I don't think it's not that you have special benches only for curative or for infrastructure. I think the time has come in Supreme Court to have special benches subject-wise. With the expertise which one honorable judge has, there should be special benches and those judges should hear only those matters. It becomes easy for the honorable judge also because you have passed a judgment on that subject six days ago. You know what you're dealing with. Now, so that it also brings uniformity in the law. So I feel that especially for commercial, which will also include your infrastructure, you must have specialized benches. Supreme Court did toil with the idea of tax benches. And a lot of tax matters were disposed of. So why not for commercial matters? Why not for arbitration matters?
Point very well taken. I'll go to Advocate Mahesh Agarwal on this. See, my question to you is that when a corporate files a curative, maybe there are 50,000 jobs involved. Maybe there is a $2 billion investment. And they will try their best to somehow, in a sense, get some relief from the Supreme Court. Why I want to ask you is, you mentioned in your first answer the issue of interest cost. And if this is involved, do you think it should be the projects of national importance? A factory that employs 30,000 people is a project of national importance. It generates livelihood for 2 lakh people or the dependents or, the end user. There could be many dependents on a factory. Do you think Supreme Court should closely look at these cases wherever huge employment is involved and industry is involved? Because it may involve lakhs of people in the entire ecosystem that this one company supports or one project supports. Could be an infrastructure project, could be a company. I would also like you to draw your attention to Justice Richard Posner, who spoke about the economic law theory in the United States. He said that the economic impact of a project should not be divorced from law. You should study what economic impact a judgment of the Supreme Court may have. And of course, there were earlier criticisms in 2G when Supreme Court in coal or 2G cases ignored that element. And 12, 13 companies overnight had to shut down and go bankrupt. It still is having an impact on the economic and the banking system because a lot of their vendors also went bankrupt. Could you give me a composite answer on this?
So I feel that first and foremost, the priority should be to support the industry so that infrastructure projects come on, employment is given, and there is work which is generated, rather than stopping a project. So where there are two views possible, the view should be to support the industry.
Yes.
Now, if a project is stopped for, say, environment reason or some public interest litigation, therefore there is some issue there. Only then it's stopped. The issue has to be addressed. It has to be solved so that the industry comes up. Now, there is no point in holding up industry or a development for 10 years, 15 years, 20 years. Earlier, if you remember, about 20 years back in Bombay, when all these mills were
Redeveloped.
mills, were stopped and they were privatized for the purpose of development. For many years, there was a delay. Who suffered? Bombay suffered. All the real estate prices went up, cost of construction went up. Now, those issues, which were essentially environment issues, could have been solved very easily. So, if there is any issue relating to any infrastructure project, the objective of the court has to be to solve the problem, rectify the issue, find answers so that the environment issue is solved. So we are not saying that there should be any damage to the environment, but the industry has to be supported. The factories have to come up. So there can be a sequence or a special bench which is assigned to deal with all projects where the projects are stayed. A current issue which is going on in the Supreme Court is with regard to ex post facto clearance. So what was happening is, supposing a project is coming up and there is some violation, you can go back to the government and get ex post facto clearance even after the completion of the project.
Yes.
In January first week this year, that was revoked by the Honorable Supreme Court, that the government cannot give ex post facto clearances. As a result of which, hundreds of projects which are going on, hundreds of industries which are working have come to a complete standstill. Now, that litigation, that one particular case, if it is taken up and decided, many problems will be solved. There are companies which are in IBC, people have taken over and they want to restart the companies. Maybe the prior management had done something wrong, because of which there was some environment issue. The government is ready and willing to give ex post facto clearance and solve the problem of environment. But the court has currently said it can't be granted. So these are the issues of the moment which need to be decided so that the cost over are avoided. What happens is the companies come, supposing you take a company in IBC and the clearance is not given or the environment clearance is not given. Again, it will go back to IBC. What can a new promoter do if he's not able to run the industry?
Yes.
Priority has to be given to industries which have been stopped by orders of the court or by the government or as a result of PIL. The environment issues should be solved and the project should come online.
That's a fair point. Point well taken. I'll go to Ruby Singh Ahuja on personal liberty. Justice Khanna has shown great promise. We saw the recent bails that came through. Of course, that will continue because we know how he thinks, that he stands by personal liberty. But in that, 50, 100 people will get bails. But I'm coming back to projects of importance, infrastructure and companies where lakhs of jobs can be impacted by one judgment of Supreme Court. If he gives 10 judgments, maybe 1 lakh jobs are important. And 4 lakh people can live lives because they'll get salaries. And of course, Supreme Court can say in 6 months, we resolve disputes for 10 lakh crores. They may have ruled against a rule. I'm not on that. But they give finality. So at least the promoter can move ahead. Okay, I'm getting permission. I'm not getting, I'll do something else. But hanging in balance is where salaries are not paid. Even bank installments are stuck. Do you think Justice Khanna can make a difference if he focuses that, okay, in his tenure, projects impacting 5 lakh, 10 lakh jobs where thousands of lakhs of crores are stuck, see the light of the day? My second question to you is, recently an HCC, Hindustan Construction Company, arbitration award was adjudicated. They won finally in the Supreme Court. The award came in 2009. The Supreme Court adjudication happened in 2024. So between the award and the final adjudication, 15 years were wasted. Because as so ADR loses its purpose if it takes too much of time. Do you think that arbitral cases which have found their way to the Supreme Court should be given some priority? Because investment in India by foreign countries hinges on this quicker dispute resolution. Do you think arbitral appeals should be given some due importance in this tenure of Justice Khanna, or something should be done? If you could share this.
So Tarun, first thing first, of course, arbitration awards should be any petitions which are pending in the court dealing with the legality and veracity of the arbitration award should be given importance. But I must come back to where you started. I don't think so it is this or that. I don't think so if that you should give, importance to personal liberty cases because, or at least 10 people will get bail. Vis-a-vis, you should give importance to cases of infrastructure where a lot of people will get job. Both are important. And I don't think so when you are in your 75th year, you can say to the public that I was hearing bail, this court is going to hear bail cases, so we don't have the time to hear infrastructure cases or vice versa. There are a lot of courts, we do have the infrastructure, we do have where it all, it's just needs some management and both cases can be heard. I mean, even personal liberty cases can be heard, and even cases for, because both are equally important. You need economic, atmosphere also to thrive for the middle class, lower middle class to come up. That's one point. The thing is that, we need certain, side twinkling here and there to make our system more stronger. We do not, as far as we do not have any time limit. The judges must, according to me, put time limit. We have seen cases being argued for three days, four days, on small points. So if we start doing that, I'm sure the court can manage both. Now, coming back to your arbitration awards, yes, of course, the court must give importance to them because our ADR is going weak. I have said it a
Yes.
number of times, and I say it again. No amount of seminars, no amount of conferences or public speaking you can have on arbitration and think that India will become arbitration hub. It will not, because we still treat arbitration as a stepsister. Even the practicing lawyers treat it as a stepsister, and the court's interference has to stop with the awards. See, you have a system in the Arbitration Act where if it doesn't get over, then you go to the High Court, you get an extension. So there has to be some limit. There are arbitrations which are going on for 3 years. So if those things are first put in place, then of course, Supreme Court should also give importance to arbitration awards, because, and it's not that difficult. It will help to bring some certainty for the commercial world also, whose cases are lying and then they lose money. They just lose money. I'm totally with that. But I don't think so. It should be this or that. It should be for all.
It should be for all. Point well. Mr. Mahesh Agarwal.
Unfortunately, our courts have not really supported the ADR system.
Exactly.
The legislature has done it. The parliament has done it. They have fixed a time limit that in 12 months or 18 months an arbitration should get over. And to large extent, nowadays at least, the courts are following the timeline. In few cases, of course, if the evidence, etc., has to take time, it's a different matter. But more or less, timelines are being followed. But what is happening is there is no timeline in the court.
Yes.
After 18 months you spend in arbitration at 34 level, normally I give an average that takes about 10 to 15 years for an award to see a result. It's 18 months to 20 months in arbitration, 2 to 3 years for Section 34, which is the first challenge, 2 to 3 years in Section 37, second challenge, and about 2 years in Supreme Court. In all, from the initiation of the claim to money in your account, it takes 10 years. So how is the court supported? Now, when there is a time limit for an arbitrator to decide the matter in 18 months, the court should do it in 3 months. Otherwise,
Yes.
there's absolutely no point.
That's a fair point. Mr. Mahesh Agarwal.
But Mahesh, sorry to interrupt you, but this disposal by the tribunals also in 18 months, I tell you, we are seeing it more in Delhi, Bombay, the cities which are more commercial hubs. I have been doing arbitrations in some other parts where it is not happening, where even it's very difficult to get a basic hearing done, because people don't believe that you have to take it seriously as a step. If the government is there, suppose you have to take money from the government, you are a company, you have done some project from the government. Now, if you keep on giving adjournments, you don't even have you have not reached the evidence stage also. When will that commercial entity gets its money? It will be a 20-year thing. And I've seen them, then companies just pack up.
That's
pack up.
Your point of companies packing up is very important, because I'll go to Mahesh Agarwal on this, that today promoters sitting in Singapore, London watch you because they want to know what the Indian legal system is up to. But they also watch every word said by a Supreme Court judge in an important economic case. And if they see that the statements coming from the Supreme Court are anti-economy, or that leads to loss of business, for them, they have 50 countries to invest. They simply change their investment strategy. The money goes to Taiwan or some other country where dispute resolution is quicker. Maybe because the countries are very much smaller, the caseloads may be lower. But the point is, India loses money. India loses investment. Given that as a fact,
You're right. The courts have to support the entire system. The courts have to support industry. The government is doing whatever it can to invite investment into the country. But if on a simple PIL, projects are stopped,
yes,
correct? This whole culture of PIL has to somehow stop. You have to trust the government. If the government has given an environment clearance or some air water clearance or whatever clearance they've given, how can the court stop it and injunct it on a PIL by some busybody? You have to trust the government, defer to the government decision. Even if a PIL is pending, at least no interim order should be passed.
one quick follow-up with you before I go to Ma'am Ruby Ahuja. in infrastructure cases, roads, we see dozens of PILs. Do you think the court should quickly dispose when these kind of roads are being made, or already roads are made, tolling has started, those kind of projects? Because in infrastructure, this is very rampant.
So you're absolutely correct. India's development is completely linked with infrastructure projects like roads,
Yes.
etc. It not only get investment, it speeds up industry, speeds up business. Now, if the courts interfere with construction of a road or for land acquisition on some PIL or some petition, it escalates the cost and the entire investor interest in the country falls. Why would anybody sitting in UK and USA invest here if there's a risk of the project getting stalled for 5 years and 10 years? So the focus has to be to somehow defer to the decision of the government where a clearance has been granted, and the court should be loath in interfering with that.
Point well taken. Ma'am, I want to ask you, can the Supreme Court, in your view, designate certain kind of cases as projects of importance where they are dealt with quickly? For example, infrastructure projects where public money is involved, because in the end, the promoter puts in 10%, the banks finance 90%. So it's public money at stake in every infrastructure project. The bank lose out if the project goes. Secondly, you yourself are a part of many such cases. Any suggestions on how to stop the dealing? If it's an infrastructure project in Supreme Court for 7 or 8 years, if an SLP is stuck for 7 or 8 years, then everyone loses hope in the end. Your inputs on this.
See, Tarun, your thought is very noble that, Supreme Court should categorize certain projects as project of national importance, but practically it will be very difficult for the court to do. You have very robust writ system and, Article 14, you will have 30 petitions at least on day one saying as to why this is of public importance and why this is not of public importance. So I think that will be a very difficult task for to put this owner's job on our honorable judges. But having said so, to say yes, of course, the SLPs which are pending for 7 years, 8 years, as I said, you have special benches. You please put the, as far as the lawyers and counsels are concerned, put deadlines as to how much you will argue. You stop adjourn, though Supreme Court is very strict about adjournment, I must say here. And, they are not given easily, especially in final hearing matters. The time limits of pleadings, of even service and all should be done. And one important part where I'm telling you, PILs will stop drastically is this. If any court, while giving an injunction order on a project, a road project or a coastal road or any industry, suppose a PIL petitioner says that this environmental clearance is wrong or right. Now what are you doing? You're challenging a decision of the government, which has gone through various levels. Now, if court on prima facie feels that they have to give injunction, at least you put an onus on that body, whoever is the PIL petitioner, to deposit certain money, which will be like, if tomorrow, if you lose, then you must give that money, because what you're doing today, you get one stay and you put the company out of pocket. Or it's not only about financials, your business plans, your other plans go for a toss. So if once you start doing this, once you start telling people you will have to pay before, pay in the sense that you'll have to deposit money or have some sort of a condition attached to an interim order, it will reduce. I am sorry to say sometimes PILs were filed, as Mahesh, I'm sure, will back me up on this, for sheer publicity also. So if you stop this, if you put these conditions, there will be less people who will knock the door of the court just for the heck of it. I'm certainly not saying as a litigating lawyer that you stop PILs. They are a good part of our system, of course, but I think they've gone too far.
They've gone too far. One final comment from each panelist. Your wishes to Justice Sanjeev Khanna on his 6-month tenure. What is your wish for him? Because, this is the biggest position he ever achieved, is the Chief Justice of India. I mean, you have to be really blessed by God. It's not easy. I mean, there are so many permutations, combinations, age in India, seniority, then you become. But this is the pinnacle of where you reach. And of course, he moves into a next career after this, maybe arbitration, maybe something else. So this final 6 months of his tenure, though it's at the top, it's just 6 months now. What's your wishes for him for these 6 months?
So we had Justice Chandrachud just retire, after a long tenure of 2 years. He's done a lot for the Supreme Court in all respects, from the time you enter the court to the courtroom, and generally live streaming, e-filing. We don't have to carry bags of files to the court. Everything is on iPads and computers. A lot of things have been done in the last 2 years. And I'm sure Justice Khanna will be able to carry on that thing further. Some issues which have cropped up in the recent past are, number one, what has happened is now a good thing for lawyers is that between in front of code 1 to 5, now we have air conditioning. But because of that, the space has got reduced. There's no place to walk. So I think, and there are senior lawyers, they're not able to walk, there's no place to sit. It is very inconvenient. I think a system has to be brought in by which the matters are listed in category wise. Say, supposing, say 20 matters in the first 1 hour, you don't have to wait for item 50 from 10:30 onwards. So some system can be followed so that the crowd adjustment or the crowd management is there. That will go a long way. Air conditioning is very welcome, but you cannot have 1,000 lawyers standing in front of court right from 10 to 4. There has to be some management. Second, in terms of filing and listing, earlier the system of the Supreme Court used to be that you file the SLP, the registry will take out defects, you cure the defects, and the SLPs are listed. Now, for last few years, another stage has been introduced of verification. Then nobody understands what is the meaning of verification other than filing, etc. Now, verification takes many days. Now, one good way could be moment SLP or the petition is numbered, you should have a listing date so that the registry has a time limit of doing the verification. It is their job. No, we have no role to play in the verification system, but the registry can spend many days in that. So between the numbering and listing, a date is fixed and the registry does the verification during that time. As a result of it, lot of time will be saved. Just now, many days are wasted only on this verification and unnecessary procedure steps, which are of no consequence.
Point very well taken. I'll go to Ma'am Ruby Singh Ahuja for her comments on this final and this whole 6-month tenure of Justice Khanna.
My first wish for Justice Khanna will be that we let him work without let us all allow him to work without controversies. Our system has gotten, something has happened that, everything has become controversial for no rhyme or reason. So let us allow the honorable judge to work in peace without raising unnecessary controversies. That will be my first wish for him. And secondly, this is what I have lifted from Twitter, and I must, if anybody is hearing this, a lot of the younger members of the bar have been writing, and I think it's a very, very good point. You see, now everything is on iPad and all, and there are two softwares which we lawyers use, which is called Liquid Text and I think PDF Expert, sorry, PDF. So Liquid Text is more in demand, and I am told that it is used more. So many lawyers have been writing that if there can be some sort of a contract with the company to give some reduced rate. I'm speaking on behalf of the younger bar, which I read on the Twitter. I can't name the people. I don't even know whether they were correct names or not. So that if it can be done, even if Apple can, see, Apple all over India give discounts to students. If younger members of the bar can get us instrument on, Apple iPad, or because it has become a necessity, then why not? And my last thing, which Mahesh has touched, somebody once commented that your court, infrastructure-wise, is not very friendly to the client. And I totally agree. There are no places for clients to sit. There are some chairs, which is, imagine sitting in July and August. So I think all is well. Our courts are inside, it's air conditioned. We have now best system for, online hearings, this and that. But I think some focus we must give there. And otherwise, I think it's all very well. Supreme Court is functioning very well. We don't have to bother. It will function well.
Thanks for that wishes for Justice Khanna. So, he's the 51st Chief Justice of India. Every word he says will be watched by each one of us. And I don't want to comment on controversy, but of course, everyone is watching him, and the next 6 months, every word of his hangs in balance. Everyone will analyze, overanalyze. But one thing that I would also wish to say, that 100 years from now, some boy or some law student searching for 2024 November to the next year, which is 25 April, May, all his judgments, when he searches, he will find out, he will read what he had done, because these days, whatever you do is there for posterity. You go down in history, your judgments go down in history. And of course, people research, read, write, comment, even years later. It's a very important tenure. We wish him well. I would like to thank Advocate Mahesh Agarwal, Managing Partner of Agarwal Law Associates, Advocate Ruby Singh Ahuja, senior partner with Karanjawala and Company, both leading law firms at the Supreme Court. You both found time for Justice Khanna. You came, you gave your suggestions, really value your time and appreciate your inputs. Thank you so much for coming in.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.